Effectively, the civil rights case is held that the civil rights case is held that the civil rights case is held that when you have state action, Congress can step in, but for private action, you cannot. But even then, the case didn't have much salience. Because the next case, I'm going to jump ahead to number 42. This is another case that everyone should know. It's called Plessy versus Ferguson. In this case, the state segregated train cars. It said that you have to have a black car and a white car. So here you had state action. But the court said that was permissible under a doctrine that came to be known as separate but equal. So long as the accommodations were separate, they could be permissible, right? You could have separate accommodations, so long as they were equal, you were fine, right? So if you had a white car and a black car, the two separate cars, no problem. Which is a stunning holding if you think about it. But that was the law of the land for decades. So in the civil rights cases, the court held that Congress can't prohibit private discrimination. And then in Plessy, they held you can have state segregation as long as it's equal. Yeah. Told you it got worse. Oh boy. You're testing me. 1896. I think it was Chief Justice Waite. Waite, but you can Google me. I'm not sure. I think. Let me check. Let's see if I'm right. Oh, Fuller. Damn, I was off by one. Waite was the guy before Fuller. It was Melville Fuller. Damn it. I was off by 10 years. Waite was in 1888. This was 1890s. Okay. Damn it. Okay. I got stumped. I used to know this. Okay. Go ahead. What's your question here?
Yeah, just to be short. You said that in case 42, you can have state segregation as long as it's equal.
Yeah, again, that's no longer the good law, but that was a law at the time.
But it is equal in the same state?
No. I mean, you have a white car next to a black car.
No. The same number of seats, for example.
Yeah.
Oh, okay. It's
Yeah. But they weren't actually equal. The cars were not even remotely comparable. One was nicer than the other.
Yeah. Okay.
So, I mean, even on its own terms, the doctrine made no sense.
So if you have, it's related with the things of the bathrooms and stuff, if you have a white and for
This gave rise to the idea of segregated schools, where you had a school for white children and a school for black children.
and public buses and
Separate buses used in the front, separate in the back, separate train cars, separate water fountains, separate bathrooms.
So it's regulated segregation.
Yes, the state can engage in segregation as long as it's equal, but it's actually equal. We'll get
But
to
the Congress can't get in.
Congress can do nothing about it because it's permissible. Okay. Yickel v. Hopkins, I'll just mention briefly, was a bit of an outlier case. Involved Chinese people. I think it was several Chinese students, right? At the time in California, there were a significant number of Chinese immigrants, and they performed in large numbers in the laundry field. They had a lot of laundries. And the state or the city passed a law that basically made it impossible for Chinese immigrants to get permits to run laundries. The white launders got their permits, but the Chinese people did not get their permits. And the Supreme Court held that this was illegal, that you couldn't deny the permits to these people on this basis. It was a completely arbitrary regime. So that was a case where the court sort of did something to scrutinize racial segregation, but in Plessy they went in the very opposite direction. Okay, any questions? Right on time. Okay. The cases in the aftermath of the Civil War narrowly construed the 14th Amendment. The next batch of cases in Part 7 focus on a different part of the 14th Amendment. Instead of the Privileges or Immunities Clause, they looked to the next part, which was the Due Process Clause, which says that a state cannot deprive a person of life, liberty, or property without due process of law. Okay? Life, liberty, or property without due process of law. What is liberty? These cases will begin to expand a concept called substantive due process. Right? Substantive due process. What is? Right. What is substantive due process? Okay. This is the part that gets real controversial. Due process refers to procedure, right? You get a trial, you get a jury, things like that. But the word liberty is in there as well. Are there some laws that are so awful that no trial can save them? I'll give you an example, right? Let's say a state enacts law that says everyone draws a piece of paper from a box, and someone who draws the red piece of paper gets executed on the spot. Is that fair? Yeah, I mean, it's fair. Everyone draws an equal piece. There's no cheating, right? But it's freaking insane, right? If a law is so arbitrary, so nuts, in other words, a judge decides a case by flipping a coin. It's fair. 50-50, right? Hunger Games style, right? You decide who gets the win. Substantive due process is the argument that some things are so unfair that no amount of process saves it. And so the court asks, what exactly then is liberty in such a case? So let's start with the first one, which is an obscure case to most foreign countries, people. Lochner. Lochner versus New York. Joseph Lochner was an immigrant in upstate New York, and he ran a bakery. And bakeries are unique. Anyone ever work in a bakery? Bakery is a unique job, right? Why? Because there's a lot of waiting around, right? You have to make the dough and you have to let it rise for a couple hours, right? Then you have to put it in the oven and you have to let it bake for a few hours. Then you have to, cut it up. And, there's a lot of downtime. So very often bakers this time, especially immigrant bakers, they would build ovens in their basements and they would basically just work around the clock. They would make the dough and they'd sleep a little bit and they'd, bake the bread and let it sleep, New York passed a law that said bakers cannot work more than 60 hours a week. Maximum 60 hours a week. Now, if you ran a big bakery, this was not a problem. This was easy to comply with, right? You just hire multiple bakers. But if you have a small bakery in your basement with like 3 or 4 of your uncles working there, right? You can't afford a 60-hour work week. They might work 90 hours. That's what people usually do. So Lochner challenged this law. He argued that it violated his liberty, what's called the liberty of contract. That is the right to negotiate wages and hour contracts with other people according to the business conditions. And this decision, the court agreed. And it held that the maximum hour law was unconstitutional. That the state of New York could not prohibit people in a bakery from working because this was not a dangerous profession and people should be allowed to work as many hours as they want. Now let me tell you, this is not a good law anymore. In fact, Lochner is often viewed as an evil case. I don't think it is. I'm a bit of an outlier in this one. But many law professors will say that Lochner is as bad as Cormato and Dred Scott. I don't quite agree. This is an unpopular case because it allows courts to second guess the wisdom of economic regulations. But this was an important case at the time. Any questions on Lochner? All right. The next 3 cases were economic liberty cases from the Progressive era. Now, we've already talked about the progressive era, right? We talked about federal laws in the early 20th century about sugar monopolies and lottery tickets and child labor. These are not cases involving Congress. These are state cases, right? They're involving the 14th Amendment, not the Commerce Clause. Okay? So the first case is called Mueller against Oregon. Here, the state of Oregon enacted a law that regulated the hours of women. Men can work as many hours as they want, but women can only work so many hours a week. Why? Women were viewed as inferior. They weren't strong enough. They couldn't work as many hours. In fact, there was a fear that if women worked too much, their reproductive organs would not operate. I'm serious. This was actually a fear that if they worked too much, their stuff would fall out. I'm not joking. I swear I can show you stuff, right? They actually believed that women were physically inadequate. There was one brief filed which said that women have more, I'm not making this up, more water in their blood, and they cannot work as many hours. Okay. Now again, in Lochner, the court held that the states could not limit the hours for bakers. But in Mueller, number 44, only 3 years later, the court held the opposite. They said that the state could limit how many hours women could work because women were inadequate and inferior. Yeah, it's a weird thing. It's like, yeah, we like our laws, but only for women? What the hell is that, right? Then we go to another case. I'm going to skip 45 for a minute. Let's go to 46. Atkins versus Children's Hospital. Here, the District of Columbia enacted a law which set a minimum wage only for women. You can pay men whatever you want, but women had a minimum wage. And you might think, wow, that's great, right? Helping women. But the court said that was unconstitutional. Why? It discriminated against women. It treated women as inadequate, as inferior, as basically idiots, that they weren't smart enough to negotiate their own labor contracts. That let a woman negotiate her own wage, don't tell her what to earn. And whenever I teach this, my female students are sort of like conflict, like, wait a minute, whoa. I like a minimum wage, it's good, but you're telling me I need this wage because I'm an idiot, right? So how do you balance that? It's a tricky case because the decision from the majority was very pro-feminism, saying women have equality, let them negotiate their own wages. But at the time there was a political cartoon that said that women have a constitutional right to starve to death, right? So they can't actually negotiate their own wages, but in theory they can. So any question on number 44, 45, or 46? Number 45 is an odd case most people don't know, called Buchanan versus Warley. A city in Kentucky enacted a law which said, if you live in a block or a neighborhood that's mostly with white people, you can't sell your house to a black person. And if you live in a block that's mostly black people, you can't sell your house to a white person. The idea was keep the races separate, right? It was prohibited to sell property to someone of the opposite race. Supreme Court said that was unconstitutional, right? That was unconstitutional. That you could not violate the liberty of contract. It wasn't about racial discrimination, because Plessy versus Ferguson was good law, separate but equal. You have separate neighborhoods. What the court said was that I have a liberty interest to sell property, and you cannot infringe upon that. So the same rights of the bakers to make their own hour contracts means that the right of the black homeowner to sell whomever he wanted to, right? So it's actually a right of contract, which is economic regulations.
Sorry, you said the owner was black?
In this case, the owner was white, but it would work either way. A white could sell to a black person, or black could sell to a white person. It works both ways. But thank you. You got to keep me honest. By the way, I am so grossly condensing the facts of these cases to finish on time. I'm leaving so much stuff out. But if you want, read the full book. But it's insane the amount of stuff I have to compress. But I'm doing the best I can. I'm actually right on target as well. Case I have to go up to before noon. Yep, I'm on schedule. Okay. All right. The next three cases concern what might be called personal liberty. Okay? Personal liberty. Okay, what does that mean? What are people allowed to do with each other? Love, family, sexual stuff, right? There are things that people do that the state might not have an interest in regulating. So let's start with Myron, Nebraska from 1923. This was a case decided after World War II, when there was a lot of prejudice in America against Germans, right? We don't think about it today, but we had a war with Germany. And there was a lot of, any Germans here? No hard feelings. Not messing with you. But there were a lot of hard feelings in America towards Germans. And the state of Nebraska enacted a law that made it a crime to teach foreign languages, including German. You could teach ancient languages like Hebrew or Greek or Latin, but you cannot teach alien speech like German, Spanish, Italian, languages that would not be friendly. And you actually had a teacher who got arrested for teaching Lutheran Bible stories in German. You can imagine that. And the Supreme Court held that that was unconstitutional, that parents have the right to direct the upbringing of their children. And if parents want their children to learn this language or that language, they can. Okay? The next one is called Pierce v. Society of Sisters, 1925. This case was born out of anti-Catholic animus. Again, there was a lot of Catholic hatred in the United States. Huge, huge. People don't remember that, but it was a big deal. At the time, Catholics had private schools in the same way they do today. You know, the Society of Sisters were a group of nuns, and they operated a school. The state of Oregon said it's a crime to send your child to public school. I'm sorry, it's a crime to send your child to private school. That you'd be fined if you send your kid to a private school. In other words, shut down all the private schools, everyone goes to public school. The Supreme Court said no, that's unconstitutional. That again, people have the right to direct how their children are raised and what their children learn, and you cannot force them to go to a public school. Now, the state can regulate curriculum and what the private schools teach, but you can't tell the parents where to send your children. Yes, in the back.
So it's not just making a fact related to it. Homeschooling in the US, I understand, is
Alternate, exactly, yeah.
because of the parents' right.
Exactly, yeah. Every state in the union allows homeschooling. What homeschooling is, you can basically teach a child at home. The state sets certain standards you have to teach, but you can teach your kid at home if you meet those standards. Yeah, it's very common in America. Yes.
I have a question. Who prohibited the Catholic schools?
The state of Oregon.
Oregon.
Yeah. And not just Catholic schools, also like a military academy, right? Any private school, it's not for religious, all private schools were shut down. Okay. The next case is a tough one. I think it's one of the most difficult cases for me to teach. It's called Buck v. Bell. Does everyone know the word eugenics? Okay. Eugenics, E-U-G-E-N-I-C-S, eugenics. Eugenics is a concept often associated with Nazi Germany, which is the idea that through breeding, you can create a superior race. And if you exclude inferior traits, you can make society better. Now, most people associate eugenics with Nazi Germany. Started here. The United States was the, I don't want to say creator, but the major innovators in eugenics. And the early 20th century, many states decided they wanted to help improve the human race. How would they do this? To prevent undesirable people from reproducing. So one way they did this was to make it a crime to marry someone of the opposite race. It was a crime for a black person to marry a white person. That way they wouldn't reproduce. Now, back then, if you weren't married, you couldn't have children. It was illegal, right? To have children out of marriage. So they would make it a crime to have interracial marriage. But other states decided to go further than that. And they decided to create sterilization programs. Yeah?
Why the name of the case is private person instead of the state?
Carrie Buck was the name of the woman. Bell was a doctor who worked for the state. He ran the program. I'll get there in a second. Virginia enacted a law which said if the state decides that a person is an imbecile, they will be sterilized, men and women. A vasectomy or the fallopian tubes they would cut. They picked a woman named Carrie Buck very deliberately. They wanted to show that imbecility was hereditary, that your mother was an imbecile, the daughter was an imbecile, the granddaughter was an imbecile. And in Buck v. Bell, the court upheld this sterilization law. It's a very tough case. It's short. If you want to read it, just Google it. It's only a couple pages long. But it's one of the most brutal cases you'll read. The opinion is written by Justice Oliver Wendell Holmes, a very famous judge. And he had one sentence where he said, 3 generations of imbeciles are enough. Basically, Carrie's mother was an imbecile, Carrie was an imbecile, and the daughter was an imbecile. And they want to cut off that bloodline from reproducing. Now, why did the court think that these people were imbeciles? I'm sorry, go ahead. This wasn't people with a mental handicap or low IQ, however you want to measure it. The mother was considered imbecile. Why? She apparently had birth out of wedlock. She was not married. That made her imbecile. The daughter, Carrie Buck, was considered imbecile. Why? She also had a child out of wedlock. She was not married. She was raped. That's why she had a child. And the daughter was 6 months old. And they said the daughter was low IQ at 6 months. It was also an imbecile. It's all bullshit. I'm sorry. It's all garbage, right? It wasn't accurate. But they created this family tree of all these hereditary imbeciles, one after the other, to justify her sterilization. It's not even clear Carrie Buck understood what they were doing to her. They would often lie to women and say, oh, we need to do a hip surgery for you or something, right? It's an awful case, and it's one of those awful cases in the Supreme Court's entire canon. It was 8-1. It wasn't even close. There was only one dissenting vote. Buck v. Bell's still good law today. There are still some instances where the state sterilizes people. For example, let's say there's a sex offender who might be released early from prison, and they give him a choice. You can stay in prison, or you can go through a castration.
So Buck lost the case?
Carrie Buck lost the case. They sterilized her. She lived a long life, but she never had children. She got married a couple times. And after she was sterilized, they released her from this home. They basically were, the government said, we can either keep you locked up forever, or we can sterilize you and release you to the public so you can't reproduce. And instead of locking her up forever with her organs intact, to let her out. It's a tough case. It's still good law. It's still good law today. Never overruled. Okay, any other questions on this one?
Sir, just one
Yeah.
question. In this situation, the person has children without, in this situation, like a black and a white person. Will these children suffer some consequences of this situation?
Under this rule?
Yeah.
Well, under this rule, if a black person and a white person were married, it was illegal. It's a crime. They got to arrest the parents.
Yeah.
And in other words, if the parents were not legally married, the children were considered legitimate. The word bastard. And under the law, bastard children could not inherit property. There were certain disabilities. So if you were the child of an interracial marriage, there were certain disabilities imposed upon you. It was a big deal. It was a huge deal. We'll do a case of interracial marriage after lunch. I promise. If you want to a little bit later. All right. Other questions on this one? Yeah. We're almost done. We're actually right. I got 2 more slides to get to your lunch. Okay. All right. The next case discusses the New Deal. And we already talked about the New Deal earlier today in the context of federal law. Right? This is when Franklin Roosevelt was president. Through the New Deal, the Supreme Court expanded the scope of federal power. Remember substantial effects and the wheat case and the lumberjack case and the steelworker case. During the same period, the court began to expand the ability of the states to regulate economic conditions. Right? This we call economic liberty through the New Deal. So we have 3 cases. The first case is called Gorman. It's a fairly boring case, but it was significant. There was an insurance company that had a contract that said, we will pay a reasonable commission. Well, what's a reasonable commission? The state said reasonable means 20%. And this company said, no, we want 25%. And the court said that the states are allowed to decide what reasonable commissions are, and they can regulate prices. The next case is easier. The state of New York regulated the price of milk. Right? They said milk costs whatever, 10 cents an ounce, a gallon, whatever it was. I forget the number. Right? Milk costs a certain amount of money. And you had a grocer in upstate New York who charged less than the price of milk. The Supreme Court said that you can't do that. That in order to protect dairy farmers, Congress can set a price for milk, right? A minimum price, and that ensures dairy farmers get their profits. Now again, none of that money went to the farmers, right? That was actually kept by the distributors. So the law was garbage. But the idea was courts will not second guess, they will not doubt the legitimacy of these sorts of economic rules. Then we have an important case of West Coast Hotel v. Parish. We previously discussed Atkins, which said that the state cannot enact a minimum wage for women, right? That minimum wage for women is unconstitutional. In West Coast Hotel v. Parish, the court reached a different conclusion. The court held that yes, women are vulnerable, they are inadequate, and the state can enact a minimum wage to protect them. West Coast Hotel overruled Atkins versus Children's Hospital. West Coast Hotel said, yes, women need all this help, and they are allowed to have a minimum wage for them. West Coast Hotel is also important because the Supreme Court signaled that we are no longer in the business of second-guessing government. That the government wants to regulate labor conditions, that's for the government to decide, not for the courts. So you have Lochner on one end of the spectrum, and then you have West Coast Hotel. And it spanned basically 3 decades, the court 180, reversed itself completely, that they will not scrutinize economic regulations. Are any questions on those cases? Okay. Last one, I'll let you go for lunch. Question?
No, I was Atkins versus
Children's Hospital.
Was overruled. No,
Yeah,
it wasn't.
yeah. Atkins was number 1923, and Atkins was overruled in 37 at West Coast Hotel. Okay. All right, last 2 cases. After the New Deal, the court had 2 other important decisions. All right, the first was called United States versus Caroline Products. What was Caroline Products about? Obscure. Does everyone know what condensed milk is? You can buy milk in a can, it's very sweet, right? The way it works is they take out the dairy and they put it in vegetable oil. And the reason why filled milk is good is it does not require refrigeration. It sits in a can forever. Back in the 1930s, people did not have refrigeration. It was very expensive. So this was a way to have dairy in a can. It was non-perishable. So who did not like condensed milk? Dairy farmers. Right? Dairy farmers hated it. It was competition. So the dairy farmers lobbied the states and federal government to ban filled milk. And they made up garbage that was, it was unhealthy. It was fine. Right? So Congress banned filled milk. You had one guy who said, aha, I am going to sell this filled milk, but it's not commerce. And the Supreme Court rejected it. Okay. The next case goes a little bit further. All right, everyone has glasses. I don't know what glasses are. If I want a new pair of glasses, I don't need to go to an eye doctor. I can bring my glasses to an eye doctor store. They can measure it and just create a duplicate, right? Mm-hmm. You don't need to be a doctor to duplicate lenses. It's very easy. Just use a little device. Oklahoma made it a crime to replicate lenses if you weren't a medical doctor. In other words, in order to make a copy of a lens, you have to be a doctor. Which makes no sense. Anyone, any clerk, anyone can make a copy of lenses. And the Supreme Court said, we don't care, right? Whether or not this law makes sense, it's not for us to decide. We are not going to judge the rationality of laws. It's up for the economic process. So again, you start with Lochner on one end, which carefully scrutinizes economic laws. Then you get to Lee Optical on the other end, where the court says we're going to defer. Lee Optical basically said we are not going to do substantive due process. That if a law was enacted and it doesn't violate, the Bill of Rights or something obvious, We're going to let it go. That was until 1955. It would start to change after the 1960s in the context of sexual privacy rights, rights to contraception, rights to abortion, rights to sodomy, right? That the same substance due process doctrine that was killed in the 1940s and 50s would reemerge in the sexual revolution of the 1960s. All right. Anything else? Question for lunch? Yes.
Yes, ma'am. When the Supreme Court rules on a certain law, state law, federal law, what is the effect of this law? I mean, it becomes null and void from the day after?
Generally, yes. Well, when the Supreme Court issues a decision, usually it becomes now null and void. That's a way of looking at it. Usually takes 60 days on the precise details. But after that, if a government official tries to enforce that law, he can be sued in court for damages.
And what if the other judge rules on a constitutional question? Because you said that every judge can
Well,
issue a
if the
decision.
Supreme Court says this law is unconstitutional, that's usually into the road. You don't try and challenge it again. But we have cases where, for example, Legal Tender Act, right? They take paper money. 1 year the court said it's no good, the next year reverse itself. So there are exceptions for the court to revisit multiple decisions.
But what about the other judges? I mean, at least if a district court takes a decision and says that a law is unconstitutional, I mean, this has no effect on this law or
Well,
it's
generally
just in a
when
specific case.
yeah, to your point. Generally, when a district court rules that something's unconstitutional, it only affects part of the court. The Supreme Court, it should be the same, but as a general matter, when the Supreme Court rules, basically everyone follows it. They don't have to believe it. Thank you.
Is it possible that the Supreme Court decide that a law is unconstitutional and then decide after that it is constitutional?
Yep, they reverse stuff all the time. So we did the legal tender case. Remember with the paper money? In the span of 2 years, the Supreme Court reversed itself on paper money. We have cases where the court says that the state can ban sodomy, and a couple years later say they cannot ban sodomy. Right? The court does reverse itself every couple of years. Thank you. Anything else? All right, I will see you all at 1. Thank you so much. Right on. Oh, damn, right on time. I'm good.